Welcome to Constitution Hall Pass. I'm Joe Penn, on location here at the National Constitution Center in Philadelphia, a museum that's dedicated to celebrating the greatest vision of human freedom in history, the U.S. Constitution. In this episode, we will explore the idea of separation of powers within the Constitution and how this motto helps to put limits on each branch of government and protects our freedom. So what is separation of powers anyway? Where did it come from? And how do we see it play out in our lives today? These are some of the things we will discuss in this show. To really understand what separation of powers is, first you have to see how it applies to our federal government. When the Founding Fathers were building our government, they were really worried about the national or federal government becoming too big and too strong. So they had this idea, which had been around for a few years, called separation of powers. And that means just what it sounds like. Instead of making a single federal governmental body, why not take that power and separate it or split it up? Why not take all the jobs of a federal government and place them into 3 distinct parts or branches? The idea is that no one part of the federal government has total control. Instead, the different parts of the federal government each have different roles and responsibilities. But there's a trick. After they separated the responsibilities, the founders created a series of checks and balances. Each branch of government is supposed to have some power to limit and also be limited by the other 2 branches. With this system, instead of one branch becoming more powerful than the others, they balance each other out. This also means that one branch cannot accomplish its own tasks without the others doing their jobs too. Because the roles and responsibilities of the 3 branches overlap, they often need to work together to get things done. That's key to how our government works. The process of checks and balances is at the heart of the separation of powers model. It comes from and is written into the Constitution. So what does this really look like? The United States government is divided into 3 branches. Remember the parts we talked about earlier? The legislative branch, the executive branch, and the judicial branch. The legislative branch consists of Congress, which is divided into 2 chambers, the House of Representatives and the Senate. The legislative branch's main role is to make laws. The executive branch is headed by the president, who is primarily responsible for making sure that the laws are being enforced. The judicial branch is represented at the highest level by the Supreme Court of the United States. The judicial branch is responsible for determining the meaning of the Constitution by interpreting how laws do or do not fit into it. Brilliant idea, right? Now let's meet some of the guys that came up with this idea and find out why they used it. Here we are, Signers Hall, an exhibit at the National Constitution Center that shows you the moment of the signing of the Constitution. If you visit the center, you'll have the chance to walk among giants. Before you are many of the men who wrote and signed the Constitution in the summer of 1787. So why do you think they wanted to separate the power of the government of our young nation? To fully understand why the framers were so worried about a strong federal government, we have to look back at what the country and these men had gone through in the last 12 years. In 1765, what would become the United States were a group of British colonies with little voice in the government and little protection of individual rights. For the next 10 years, the British government began restricting colonists' rights to fair trials and imposing invasive taxes without the colonists' consent. The British government stationed soldiers, the Redcoats, throughout the colonies, and even forced the colonists to keep them in their houses. And those redcoats weren't behaving themselves very well at all. The British government was even taking colonists away from their homes and sending them to England for trials, which meant they weren't getting a speedy trial by a jury of their peers. When the colonists declared independence from Great Britain, they did it for a lot of reasons, but they all had to do with the fact that individual rights weren't being respected. The people that supported independence saw too much power in the hands of the king.
The Revolutionary War was fought for American independence and to ensure that no one person or group would end up with that much power over the people.
In 1783, the Revolutionary War ended and our nation's independence was secured. But making a government that would serve the people turned out to be trickier than many had thought. At first, the new nation was so concerned about the national government being too powerful, they established a government that was extremely weak. They called this system the Articles of Confederation, and it gave most governmental power to the states. Under the Articles, the only way the federal government could get things done was by a unanimous vote of all the states. This caused some big problems. We weren't acting like a country, but more like a loose band of friends. Can you imagine how different things could be from state to state? It was a mess.
States were doing things like printing their own money, putting up trade barriers with other states, and in some cases, even building their own navies. And the British were still around in nearby places like Canada and the Caribbean, waiting to take advantage of our weak government.
So a convention, then known as the Philadelphia Convention, was called to fix our system of government. The first thing the delegates to the convention realized was that the Articles of Confederation were not going to work, so they threw them out. They knew that the national government needed to be able to take care of the country's needs, doing things like collecting taxes, raising an army, and signing agreements and treaties with other nations. But they remembered what it was like under British government, and they didn't want anyone becoming a tyrant, or to see people's rights being restricted again. So giving power to the federal government was necessary, but dangerous for the Founding Fathers. How did they strike the right balance?
They started by breaking the power into 3 different branches. They set up a system in which separate parts of the government were responsible for writing laws, carrying those laws out, and determining what those laws meant, like we discussed earlier. This idea came from the French philosopher Montesquieu. Montesquieu believed giving people the power to choose their leaders was wise, but that a single leader could restrict the rights of the people to gain control over them. If this happened, the people would become powerless. So, to protect the people from a tyrant, he proposed a system that put the power in a few different places.
This model, separation of powers, was the trick the delegates needed to balance governing the country with protecting people's rights. The 3 branches, working together under the process of checks and balances, have lasted from the Constitution's ratification right up to today.
So let's recap. Our federal government's power is broken up into 3 branches. This split of power is a way to protect the rights while still governing the country. This system is called separation of powers, and it comes from the Constitution. The delegates to the Constitutional Convention borrowed this idea from Montesquieu. Now that we know where it comes from, let's take a look at how it actually works.
So now we know the balance of the branches and the roles that each has. But how do they actually check and balance each other? Each branch has different responsibilities when it comes to governing the country, and they all have to interact while doing their jobs. Let's see how this works. Congress, the legislative branch, is responsible for making laws, but any law that Congress passes doesn't go into effect until the president, the head of the executive branch, signs it. They have to work together and agree to create a law. If the branches don't agree, the president can veto or refuse to approve the proposed law, and that stops it from becoming an actual law. This is a check on the legislative branch by the executive branch. However, to balance out the president's veto power, Congress can override a veto with 2/3 approval from both of its houses. Bam! The executive branch has just been checked.
One of the president's responsibilities is to appoint people to the Supreme Court. However, the nominee for the Supreme Court must be approved by the Senate. There's another check. The Supreme Court can check the power of other branches too. If the court rules that a presidential action or executive order is unconstitutional, the president has to listen to their decision. And the court can also strike down laws passed by Congress if it decides they are unconstitutional, a check they have over the legislative branch.
You can almost see the power tipping from one branch to the next. So, where does all this happen today? Washington, D.C. has been the nation's capital since 1800. Congress currently meets at the Capitol Building, which is located at the eastern end of the National Mall, opposite the Lincoln Memorial and the Washington Monument. About 2 miles west by northwest of the Capitol, on Pennsylvania Avenue, is the White House, the home and headquarters of the President. And the Supreme Court finally got its own building in 1935. That building is located 1 block east of the Capitol. Each of these buildings is the central location of one of the branches of government. They're the places where officials work together to get things done, but also to limit one another's power.
The Constitution spells out the model of separation of powers in the first 3 articles of the Constitution. It also spells out how checks and balances function to protect the freedoms of American citizens. Now let's see this system in action by examining some real events from American history. Let's take it all the way back to the early 1800s. President Thomas Jefferson had just taken office, and he has some problems with several officials that his predecessor, John Adams, appointed before the end of his term. One of them is a man named William Marbury, who Adams made a justice of the peace.
Jefferson tells his Secretary of State, James Madison, not to deliver Marbury's commissioning papers, which basically means Marbury can't start his new job. Marbury takes his case to the Supreme Court. He believes that the Judiciary Act of 1789, a law passed by Congress, gives the court the power to order Madison to deliver the commissioning papers. So what does the court decide? The court, under Chief Justice John Marshall, agrees with Marbury that it was illegal to withhold his papers. However, they also find that they themselves do not have the authority to compel Jefferson or Madison to act, that it's beyond the scope of their power as outlined in the Constitution.
The Supreme Court declares that the Judiciary Act of 1789, the law that Congress had passed giving them that kind of authority, is unconstitutional and therefore null and void.
Looking back, this was an important moment for the Supreme Court. The case established that the court had the power to throw out laws passed by Congress that they found were unconstitutional. This power is known as judicial review, and it's a big check that the court has over Congress. The year is 1861, and we are in the midst of the Civil War. The Constitution is being threatened by the secession of the Southern states, who call themselves the Confederate States of America.
At this time, Maryland is a border state that has a lot of residents supporting the Confederacy. Groups of these residents are rallying people to support the Confederate cause, and some of them have even started ripping up railroad tracks and telegraph wires connecting the northern states to Washington, D.C.
To try to stop Maryland from turning against the Union, President Abraham Lincoln suspends the right of habeas corpus, a long-standing right that forbids authorities from imprisoning people without a hearing. People in Maryland see this as an overreach of executive authority, since Congress would have to pass a law or an amendment to do such a thing. This was not the president's job.
On May 25, 1861, John Merryman is arrested in Maryland on suspicion of supporting the Confederacy. Supreme Court Chief Justice Roger Taney, functioning in his role as the Chief Judge for the United States Circuit Court for Baltimore, asked the arresting officer, General George Cadwalader, for a writ of habeas corpus for Merryman. Cadwalader refuses to hand over Merryman, and the stage is now set for a showdown in the federal government.
Does the executive branch have the power to keep suspects in jail during a rebellion? Can the judicial branch stop executive orders during the crisis of a rebellion?
3 days later, Taney drafts a statement called Ex parte Merryman that says that Lincoln doesn't have the power to suspend habeas corpus, and that military officers couldn't arrest people unless the courts gave them permission.
Fast forward to early 1973. President Richard Nixon has just been successfully reelected. But a few months earlier, on June 7, 1972, the police had arrested a group of burglars who had broken into the Democratic Party headquarters in the Watergate complex in Washington, D.C.
Journalists, especially the Washington Post's Bob Woodward and Carl Bernstein, soon uncovered links between the burglars and members of President Nixon's White House staff. By 1973, a special Senate committee headed by North Carolina Democrat Sam Ervin was investigating the break-in, seeking the level of involvement of the White House. The scandal became known by a single word, the name of the place where it all began: Watergate.
During the investigation, the Senate committee discovers, to everyone's amazement, that the White House had a secret recording system. The committee, working with a special prosecutor named Archibald Cox, asked for the tapes to prove that Nixon had ordered the break-in. But Nixon fires Cox and refuses to turn over any of the taped recordings because of executive privilege, the idea that the president could refuse to disclose any information he believed should be kept confidential for the security of the nation.
Both President Nixon and Cox's replacement, Leon Jaworski, appealed to the Supreme Court to determine whether or not the president could be forced to hand the recordings over. Because two of the branches of the federal government, the executive and the legislative branches, are locked in a dispute, the third one, the judicial branch, had to settle the issue.
In United States v. Nixon, a ruling issued on July 24, 1974, the Supreme Court rules in an 8-0 decision that the president still has to meet the legal obligations of every other citizen,
and orders Nixon to turn over the tapes to the special prosecutor. The new evidence damages the president's public image beyond repair. And on August 9, 1974, facing certain impeachment and removal from office, Richard Nixon becomes the only president of the United States ever to resign from office.
Good evening. I shall resign the presidency effective at noon tomorrow.
These are just a few examples from American history of how the system of separation of powers and the process of checks and balances written into the Constitution works. No one branch has total and final control. They all have different jobs. They have to work together, and sometimes they even have to step in and stop the other branches from overstepping their constitutional limits. By dividing the power into 3 separate branches, the framers of the Constitution made sure that the rights of citizens would be protected. Thanks for watching the show. I hope you enjoyed learning more about separation of powers. From the National Constitution Center, I'm Joe Penn. See you next time on Constitution Hall Pass.